Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. I had a litigant to write me and say that they filed their EEOC charge. EEOC returned the right to sue letter and wrote they did not find cause. And the individual wanted to know, can I still sue? Yes. My very first trial was a Title VII employment discrimination case. My client was issued a right to sue letter, and EEOC did not find cause. Well, let me tell you, we not only went to trial, but my client secured a jury verdict in his favor. Now remember, EEOC did not find cause. Why did my client move forward? We felt his case had the facts to establish the prima facie elements for his discrimination claims. Now remember, every claim or cause has prima facie elements that must be met. Now we believed that we had the facts to establish the prima facie elements, and not only that, the evidence that could stand against any objection by the defendant and secure a trial, which we were able to do. When EEOC issues a no cause finding, it means the agency has concluded that they did not find sufficient evidence to support a claim of discrimination or retaliation. Now, plaintiff, pro se, the responsibility is on you to find the sufficient evidence. Listen, if you know that you know that you know you have the facts to establish the prima facie elements and the evidence, even though you may not have all of the evidence in your hand or in your possession, but you know that such evidence exists to get you to trial or settlement if that's what you want, you are encouraged to move forward with litigation. Even before you file your EEOC claim, you should have a set of facts and evidence in mind, and you should have analyzed and studied both before you file your EEOC claim. Now, this competence, it will help you to complete your EEOC charge more clearly and succinctly. And if I were a betting woman, I'd say that EEOC is going to give your charge more deference or greater consideration. Now, nobody told me that. I'm just saying. And let me say this about EEOC. Even when EEOC does not find cause, its investigative results are still important and useful, plaintiff pro se, and don't let anyone tell you otherwise. There are 4 results coming from the EEOC investigative report that I look for, and those are the position statement, the separation notice, witness statements, and of course, documents. And do 3 things with this material. First thing you want to do is dissect the information. You need to read it, and you need to take notes of what's relevant. You need to analyze your case. Analyze this material. Study it. Determine which note or notes, which would include your facts and your evidence, support which element or elements. This will help you to frame your discovery questions. Now, there are tools that the litigant, including the pro se, use to assist them in making out their case or defense for that matter. And they are Admissions, Federal Rules Civil Procedure 36. Interrogatories, Federal Rules of Civil Procedure 33. Production of documents, Federal Rules of Civil Procedure 34. Now, if your case is not a federal one and it is a state case, then you need to look at that jurisdiction's rules regarding discovery. Now, if you have fully dissected and analyzed your case, you know what you need to make your case or defense. So this part should not be difficult, okay? Now, if you have a witness whose testimony is critical to you making your case or defense, you want to depose that individual. And I'm going to show you later on why that's important. So let's focus on the witness and documents. So what happens if the witness does not show up at the trial to testify? Well, it happened to me. My very first trial, one of the witnesses did not come to court to testify. But fortunate for me, I had previously taken the individual's deposition. Watch this. A witness deposition can be read into evidence at trial if the witness is unavailable to testify. This usually involves showing that the witness is unavailable and that the opposing party had an opportunity to cross-examine the witness in a prior proceeding. And that's exactly what we were able to do. Show that the witness was not available to testify. And if I recall correctly, my co-counsel asked the questions. In other words, the co-counsel read the question from the deposition. I sat on the stand where the witness would sit, and I answered the question simply by reading the deposition excerpts. It felt weird, but it was effective. Apparently, because again, my client was able to secure a verdict in his favor. And be sure to subpoena your witness for trial because you may be compelled to have a warrant issued against that witness because the court can issue a warrant for the arrest of a witness who fails to appear in court after being subpoenaed. Regarding documents, if the party the discovery is propounded to fails to respond to the discovery or otherwise cooperate, the party making the request can file a motion to compel. Additionally, a person can be arrested if they fail to comply with a subpoena requesting them to produce documents. And always have an investigator on standby. You never know, you might need them. In fact, I would say identify an investigator that you can use before you even file the lawsuit. And you know what? They are effective. And I found that they can be reasonably priced. Okay? Get yourself an investigator. And to the pro se who asked this question, here you go. I trust it will help you, and I trust it will help each of you. I am Advocate Lucinda, and we will see you next time. Take care.